Good afternoon, everybody, and welcome all of you to this panel discussion on mass atrocity response in China's Xinjiang province. My name is Anne Mikus, and I'm the head of programs of the Bonavero Institute of Human Rights at the University of Oxford. This event is co-hosted by the Oxford Program on International Peace and Security, the Oxford Institute for Ethics, Law and Armed Conflict, the Oxford Transitional Justice Research Group, and the Bonavero Institute of Human Rights. In this panel discussion, we want to examine the characterization of the alleged international crimes committed in the Xinjiang detention camps and look at mechanisms available under international law for ensuring international protection and scrutiny. We will also consider the domestic response in the UK to the allegations to date, such as the UK parliamentary inquiry launched in September last year. And finally, we will also hear about potential contributions of civil society in responding to the alleged crimes. In particular, the civil society-led independent People's Tribunal that has been set up to investigate ongoing atrocities and possible genocide against the Uyghur people. First, my colleague Federica D'Alessandra will give a short introduction to the topic and introduce our speakers. We'll then each have 5 to 10 minutes for their opening remarks. We'll then turn to questions from the audience. We are in a webinar format, so please use the Q&A window to send us your questions, which my colleague Citalina van Bentham from the Oxford Institute for Ethics, Law and Armed Conflict will then put to the panelists. Before handing over to Federica, let me say thank you to our distinguished speakers and to all of you for joining us for what is surely a really interesting and important conversation on how to leverage domestic and international law tools to influence China's compliance with its human rights obligations in the Xinjiang province. And a warm thank you to all the colleagues who made this event possible, in particular, Federica, Citalina, and Gayatri. With that, I'll now turn to Federica to frame the discussion. Federica D'Alessandra is the Executive Director of the Oxford Program on International Peace and Security at the Blavatnik School of Government. She's also a member of the steering committees for the Oxford Institute for Ethics, Law and Armed Conflict, and an academic affiliate of the Bonavero Institute of Human Rights. She also chaired the Human Rights Law and War Crimes Committee of the International Bar Association. And prior to joining Oxford, Federica held various appointments at Harvard University. Federica, over to you.
Thank you, Annalie. Welcome, everyone. And thank you for joining what I think Annalie is right, promises to be a very interesting discussion. I want to thank my colleagues at the Blavatnik School, as well as the Bonavero Institute, of course, and colleagues at the Oxford Transitional Justice Research Group for hosting today's discussion. And I'm really pleased to be joined on this panel by a very distinguished group of experts on international human rights, international criminal law, and more generally, very active in the space of atrocity prevention response here in the United Kingdom as well as elsewhere. These include Ambassador Stephen Rapp, who is currently a visiting fellow, senior visiting fellow of practice with our program. He's also a distinguished fellow with the U.S. Holocaust Memorial Museum Simon Scott Center for the Prevention of Genocide. And he's also served both as an international prosecutor at the UN tribunals for Rwanda and Sierra Leone, where he indicted former Liberian President Charles Taylor. And he's also served actually as US Ambassador at Large for global criminal justice issues under the presidency of Barack Obama. On this panel, we're also joined by Sir Geoffrey Nice, Queen's Counsel and renowned international law expert, who currently chairs the civil society-led inquiry called the UK Tribunal to investigate China's alleged genocide and crimes against humanity against Uyghur and other Muslim populations. Sir Nice has been very active domestically also in the conversation concerning a proposed genocide determination bill, which is ongoing in Parliament. And so I'm personally looking forward to his insight into that as well. Last but in no way least, we're joined by Christy Sutherland, who is a barrister and an expert in international criminal and military law. She currently holds an appointment as a visiting fellow of practice with our program, and she's also a defense counsel before the International Criminal Court. Allegations have been surfacing now for some time of gross and systematic human rights abuses against the Uyghurs, Muslim and other minorities emerging from the Chinese autonomous region of Xinjiang, where it is widely reported that between 1 and 1.5 million Uyghur individuals, with some estimates actually going up to 3 million, are being held in detention facilities where the Chinese government is said to be pursuing policies of re-education. Although the Chinese government has consistently defended its policies and action in Xinjiang, these measures have actually drawn widespread concern as well as condemnation from the international community. For example, the government of the United States, as well as the Canadian government recently, referred to the treatment of the Uyghur minority in Xinjiang as a credible case of genocide. A number of UN special procedures, as well as the UN High Commissioner for Human Rights, have expressed serious concerns about the alleged abuses and also requested immediate and unhindered access to the facilities in question. The UK Parliament, for its part, convened a parliamentary inquiry in 2020 into the allegations and requested those with information and insight into the situation in Xinjiang to submit evidence to their inquiry, a call which our team at Oxford, the University of Oxford, responded to through both written and oral submissions to Parliament, in which we provided analysis on both the domestic and the international law tools available to address the situation in Xinjiang. Both Ambassador Rapp and Christy Sutherland joined me in the submission. However, Parliament has yet to come to a determination of whether the allegations amount to crimes under international law, and the same goes for the government, the UK government. Whereas the UK civil society, on the other hand, has been extremely active on this front, convening under the chairmanship of Sir Nice, an independent inquiry of their own, intended to provide analysis as to the facts and the international law that applies. I don't want to take any more time from our panelists, so I will conclude by saying that the objectives of today's discussion are, as Annalyn mentioned, to provide a preliminary analysis reflecting on the legal characterization of the abuse being alleged in Xinjiang, which will be discussed by Ambassador Rapp. We will also survey the range of legal and policy as well tools under international and domestic law available to the UK government to respond to these allegations, in particular, given its leadership in the atrocity prevention sphere, as well as the central role that the protection of human rights plays in UK foreign policy. It is worthy of note, of course, even though this is not news to anyone, that China's role within the UN Security Council and the fact that it is not a state party to the International Criminal Court reduced very considerably the avenues available to address these allegations, particularly through the existing international criminal justice architecture. However, there are some recourse mechanisms available under the international human rights law regime in particular, which Christy Sutherland will discuss. And her presentation will cover, in fact, our program's written submission in response to the UK parliamentary inquiry, And towards the end of the discussion, I would also like to share our programs and our team's views on what Her Majesty's government might consider doing to strengthen its position with respect to atrocity prevention and response more generally. And now, without further ado, Ambassador Rapp, would you please get us started by providing us your analysis as a former international crimes prosecutor and an expert in these areas of law, of how are you thinking through what is going on in Xinjiang?
Well, thank you very much, and thank you to all the participants and hosts. I did want to note and add to your comments about governments that the Dutch Parliament this morning passed a resolution labeling the Chinese government conduct as genocide. And of course, the Chinese reacted as they often have and said this is a matter of internal affairs and it's interference in our internal affairs. I think it's important to note that international crimes can be committed within the territory of a single state, and they are a matter of international concern, and international justice and can be brought to bear in those situations. Recalling that China itself voted for the resolution referring the situation in Libya to the ICC at a time when there wasn't yet an armed conflict, when there was indeed a suppression of demonstrations within Libya, and recognize that, of course, that could be an international case. And so what's going on in Xinjiang, which certainly by all of the evidence is a reflection of government policy, does qualify, in my view, as certain international crimes. Now, how do we say that on a factual basis? There's certainly been internal documents leaked, the famous cables that describe the mass detention campaign, the Caracas list that was also leaked, which talks about the characteristics of the people that have been detained and what's occurred in that process. And that leads international lawyers to look at this in the context of crimes against humanity, which of course are crimes that occur now outside a war, and have these requirements that there has to be a widespread or systematic attack against a civilian population, that you have that there has to be knowledge of that attack by the actors in it, and that it has to be pursuant to a state or organizational plan or policy. And in this situation, you think of attacks sometimes as being entirely kinetic, like shooting people in the street, but attacks certainly include state actors and armed security police picking people up in their homes and detaining them against their will. Those are attacks as well. And the fact that this is part of organizational or state policy, I think, is reflected in the documents. Of course, we're talking about then specific acts of violence that are part of this attack, and they include, of course, the act of imprisonment or severe deprivation of liberty. More than 1 million people are now believed to be in these camps. There are at least 500 of those camps. There may have been up to 3 million people that have been through the process. That's entirely coercive. There's a deprivation of liberty in it. Children are separated from their parents during that time, put with non-Uyghur households. Even when people get back, there are now 200,000 Han Chinese working with the government that have been deployed into the homes of Uyghurs, further depriving people of liberty. So you've got that crime against humanity. You also have the enforced sterilization, which includes surgical means, but also includes the mass implantation. Indeed, something like 90% of the implantation of IUDs in China is occurring in these areas of Xinjiang, and the IUDs are being placed in the wombs without strings, so they can't be removed, and there's monitoring, and not removed by other than medical personnel safely, and then there's monitoring every 3 months to make sure that they haven't been removed. And so, that constitutes enforced sterilization, which is one of the sex crimes that are in the list of potential crimes against humanity. All of these things are done on an ethnic or sectarian basis against the Muslim Uyghur population, and involve a variety of rights that are being deprived in a serious way, and so you have persecution. This leaves aside questions of torture, enslavement, the use of forced labor within these camps, etc., other potential sexual violence on which the evidence is less definite, but without question, based upon what we can see from the skies, what we see in the documents, we've got these crimes against humanity. The big issue is, do we have genocide? And of course, in genocide, we often think of death camps like Auschwitz, or we think of massacres in schoolyards and churches in Rwanda, with the thousands, tens of thousands, hundreds of thousands of people being killed by machetes. But genocide can be committed in a number of ways, not just by killing. It includes other means which are frankly directed toward destroying a group through means such as a biological destruction or minimization. Now, there, of course, the question is that has been presented to some extent is China has a very rigid population policy, and that population policy hasn't been applied in Xinjiang in quite the same way as it has in the rest of the country. We all remember the one-child policy. It was modified by the government several years ago to now basically allow for 2 children in cities and 3 children in rural areas. And there are those that say that if China, through the forced sterilization, is simply bringing in those policies in a uniform way, can be a violation of human rights, certainly. And we're not talking here about human rights law, but those kind of reproductive decisions are a matter of international human rights law, but those aren't things you can criminalize. But the question then is there an intent? We've got an act, we've got these acts, the biological reduction through sterilization that does constitute an actus reus of genocide in the same way that killing does. But then do you have the intent to destroy the group in whole or part? And I think the recent evidence, particularly that Adrian Zenz has developed, including with demographic information, shows that in the 4 prefectures with Uyghur domination, you're seeing something like 80% of the implantation, and you're also now seeing it being 80% of the women, I should say, are having forcible sterilization, and they include women that haven't had 2 children, that haven't had 3 children. And so now you actually have, in some demographic information, the population rate as far as the Uyghurs declining. In other words, the births are less than the deaths, and over time that would effectively destroy that community in part. Genocide doesn't have to be committed overnight. So this is why legal experts, I think, can point to this being a genocide based upon that intentional biological reduction of this population.
Thank you, Ambassador Rapp. Now, I wish to turn to Kirsty Sutherland and ask her to provide an overview of our program's written submission to the UK Parliament, which is available on the events page, and I can also pop in the chat box for those interested. So, Kirsty, what are the tools available to the United Kingdom under domestic and international law to respond to these allegations coming out of Xinjiang, taking, of course, into account, as we said earlier, China's position within the UN Security Council and the fact that they're not, it is not a state party to the International Criminal Court?
Thanks, Federica. Well, I think at the outset, it's important to note that there's been a sort of an apparent shift in Beijing's narrative. In 2009, Beijing was emphasizing its severe crackdown on terrorism and extremism and blaming terrorist forces for exaggerating cultural differences between ethnic groups in Xinjiang. But then in 2020, it was changing its narrative to say that it was emphasizing Xinjiang's proactive labor and employment policies and focusing on the increased enrollment in education, which has a slightly sinister undertone for the reasons that Stephen's just outlined. Coupled with that, and bearing in mind the impact of the COVID, China is experiencing a somewhat waning popularity on the Human Rights Council and on the international stage. and it has a desire to project an image of soft power that may make it more amenable to international pressure than perhaps it historically has been. That said, China is, I think, and as we argued, Federica, unlikely to respond positively to international litigation or calls for international inquiries. And the risk is that this perhaps runs, may entrench rather than alleviate the isolation and poor conditions currently endured by the Uyghurs. And as for how feasible it is to bring criminal proceedings against individuals suspected of being responsible for these abuses, well, as you've touched on already, Federica, China holds a permanent seat on the Security Council and isn't a party to the Rome Statute, so the ICC seems pretty much off the table. The prospects of prosecution in the UK under the ICC Act also seem extremely slim, given the location of the conduct and the unlikelihood that any of the victims hold UK residency or nationality. Again, the exercise of universal jurisdiction also seems pretty slim. It's very rare, and it would be a huge political statement against senior Chinese politicians if the UK were to go down that route. So what about the human rights architecture that you were asking about? Well, we explored the opportunities presented by the use of UN special procedures. And for example, that would be the UN Working Group on Arbitrary Detention, the inquiries and advocacy of various special rapporteurs, that kind of thing. And also what we can do pursuant to the UN treaties. China's ratified and is therefore legally bound by a number of relevant UN treaties, including the Convention Against Torture, the International Convention on the Elimination of All Forms of Racial Discrimination, the Convention on the Rights of the Child, the Convention on the Elimination of All Forms of Discrimination against Women, also to the International Covenant on Economic, Social and Cultural Rights. That said, it hasn't signed the CRC or the ICESCR protocols providing for interstate complaint procedures, nor does it recognize the competence of CAT to investigate. So it's a little bit tricky there, but it does seem that it would still be open to the UK to transmit communications to the Committee on the Elimination of Racial Discrimination. The benefit of that would include that a move would be slightly less confrontational than going straight to the ICJ. And also the UK would be able to provide evidence to the CRC and to CEDAW, to the committees at least. We also explored the possibility of advocacy ahead of the next Universal Periodic Review, which China is due to conclude in 2024. The UK can basically use diplomacy to support the High Commissioner for Human Rights in their request for access to the sites to investigate. But the UK can also use its pretty powerful intelligence capabilities to make observations and pose queries to push China on its human rights compliance. The Genocide Convention, well, everyone knows, as Stephen's just set out, that genocide is defined as requiring the specific intent to destroy in whole or in part a national, ethnic, or racial or religious group. As Stephen's already mentioned, this can be achieved in various ways, including through deliberately inflicting conditions of life calculated to bring about physical destruction, including by preventing births and forcibly transferring children to another group. The destruction of culture through the purposeful erosion of defining characteristics of protected groups, such as outlawing cultural practices, destroying cultural and religious property, abolishing language, or making children live with Han Chinese groups, also seems to indicate the requisite specific intent. How could the UK get China to the ICJ? Well, we're not really sure. It's a bit tricky. China prefers settling disputes through negotiation and conciliation. It appears to be increasingly prepared to accept adjudicative settlement where it's politically expedient, but it hasn't accepted compulsory ICJ jurisdiction. It's unlikely that China would agree to ICJ jurisdiction under the Genocide Convention or other human rights treaties. So as an alternative approach, we recommended that the UK could seek to leverage US-China treaties of friendship by lobbying the US to bring a case against China before the ICJ. We advised against countrywide sanctions on the basis that this could exacerbate harm to those it's intended to help, perhaps even escalate tensions and impact, as a side correlation, the UK economy. At the domestic level, the UK has at its disposal the global human rights sanctions regulations, which would enable the UK to place effective sanctions, by which we were referring to asset freezing or immigration prohibitions, on individuals and companies involved in systematic abuses alleged against the Uyghurs and other minorities. Through this legislation, the UK would be able to sanction those responsible for, complicit in, or engaging in slavery, persecution, genocide, facilitating, inciting, promoting, or providing support for any of these activities, profiting or otherwise benefiting from such activities, and failing to investigate when under a duty to do so. So this is sort of the overlap with the private realm. We also argued, for obvious reasons, that careful consideration should be given to the most impactful attribution of sanctions if we were going to explore sanctions, focusing in part on effective authority and to the extent of how people would be genuinely impacted by them. The threat of sanctions against companies, including and most crucially UK-linked businesses with operations directly in Xinjiang, we argued would discourage private sector contribution. Of course, any sanctions would be more effective scaled up. The UK on its own may not have as much of an impact as it would like to believe. The European Union is considering legislation, but immediately the transatlantic approach seemed to us to be the most promising. The US and Canada have both already passed Magnitsky-style legislation, which the UK could, so we could take a double-pronged approach and have a significant impact on senior Chinese people considered to be responsible. That said, Federica and I argued that effectively trade negotiations present the UK with a key diplomatic opportunity to raise concerns and to set standards. And that by imposing trade restrictions, we could present discourage current actions in Xinjiang, import bans, requiring a rebuttable presumption requiring importers to demonstrate complete freedom from abuse would be a very important step, we said, in curbing the trade of tainted goods into the UK. And we know from the recent Huawei ban that the UK is able and willing to push back in this way. Aside from that, again, at the domestic level, the UK has already got legislation, including the Modern Slavery Act, the Foreign Prison-Made Goods Act, which is a very, very old act, the Proceeds of Crime Act, Serious Crime Act. All of these should already be being strictly enforced, and the UK should be doubling down on that to ensure that UK companies aren't fueling forced labour. And I won't get onto it now because I know that Jeffrey's going to cover it, but we, of course, since we submitted our regulations, there's been this parliamentary ping pong over the trade bill amendment, and I look forward to hearing Jeffrey's views on that. I'm sorry, I probably went way over my time. I'm sorry.
Thank you, Kirsty. That was actually a very quite comprehensive overview. I do agree that I will love to turn now to Sir Nice. So you obviously been spearheading this civil society-led initiative to scrutinize what's happening in Xinjiang. Can you talk us through the initiative and what you're hoping to achieve with it?
Well, thank you. I'll do my best. Always a pleasure to follow Annalisa, Stephen, and Kirsty, with all of whom I agree. The initiative of which I'm the chairman is called the Uyghur Tribunal. It's a people's tribunal, and it's sequencing, or follows in sequence, a China tribunal, which I also chaired, into forced organ harvesting. And I'm not going to express any personal view on what may or may not have happened in respect to forced organ harvesting. The conclusions of that tribunal, which were reached to the level of beyond reasonable doubt, are available in the judgment, which is fully argued and fully evidence-based and has never been attacked or deconstructed by anyone. And obviously I can't express any view about the present position of the Uyghurs. But I think it is worth saying a little something about what a people's tribunal might be, what a people's tribunal might be now as opposed to what it was in the 1960s, when the series of them perhaps began with Lord Russell's tribunal into Vietnam, a format of tribunal that would probably not be acceptable today, trying only one side of a conflict and stuffed with left-leaning people like Lord Russell and Jean-Paul Sartre, and refusing to consider the wrongs that may have been done by the Viet Cong. I suppose, actually, the nature of a people's tribunal is pretty well revealed in the title. It's a tribunal by people, for people. It's not for lawyers, not for NGO specialists or human rights, whatever they are. It's for people. And I think one of the realities that possibly is not understood before I come to our tribunal, realities of the history of the genocide, or the term genocide, we haven't got time to go into that, and many of you know all about it, but the convention, quite interesting, isn't it? The convention was, at the instigation of the wonderful Raphael Lemkin, brought to bear by people who'd seen bodies scooped up in shovels from concentration camps and dumped into mass graves. They knew about that sort of thing. And yet, when the convention was proposed, Russia, the United States, the United Kingdom, all opposed it. They didn't want it. Why? Because although there'd been some move towards globalization following a couple of centuries of primitive sovereignty, starting at the end of the 17th century, I suppose, and ending with the beginning of the control of wars at the end of the 19th centuries, and a general development of globalization, actually, most countries prefer not to be bothered with what they do on their own territory. And as a quid pro quo, they like not really to interfere with what other people do on their territories, whatever they say. The British government's posturing on the present proposed genocide convention to the trade bill is, I suppose, how would you describe it? Hypocritical. Because in fact, prime ministers of every government, or government of all political persuasions, or even coalitions, have never even thought of honouring Article 1 of the General Genocide Convention. Because it would mean saying a nasty thing about a country, and you might not find that very convenient. And in case another country might say something terribly nasty about us, and you wouldn't find that very convenient either. But curiously, and this is something that's been revealed by the great publicity given to the Uyghur problem, I think the people, the citizens, the people on the other half of the People's Tribunal probably would like things to be done. They probably have grown to understand a bit more about the nastiness of man and woman to man and woman in doing things that can be described as crimes against humanity and genocide. So what does a People's Tribunal do? Well, it recognizes these horrid realities about government. And good luck to all the measures that Kirsty's spoken of, and Stephen, good luck to them. I hope they all work. But even if they don't, even if governments will stick to their primitive sovereignty concepts, very well expressed actually, I think, by President Trump a couple of years ago and his colleague Bolton, when they encouraged basically all countries to do without the ICC and to close the boundaries to international law. Just as Lansing, the Secretary of State in the First World War, was deaf and blind to the suffering of the Armenians on the basis that what people do within their own borders, it's up to them. But the people don't think that, not anymore. And if I'll deal with the trade bill, but I must come back to our tribunal, and I will, but the trade bill is an effort by wonderful Lord Alton and others to say that if the United Kingdom's about to enter into a bilateral trade arrangement, and if there's evidence going to show that another country might be genocidal, well, maybe you shouldn't do any trade with them. And the Conservative Party government's doing everything it possibly can to stop that getting through in one form or another. It's all far too complicated and very wearying. But if, to take a nasty example, and one of the United Kingdom's immediate neighbours, starting at what, Netherlands, Belgium, France, Spain, Republic of Ireland. If in one of those countries, a particular segment of society, Muslims, some other identifiable group, was being persecuted, shot, organ harvested, put into ovens, would the people of our country, I'm sure the same would apply to the people of Steve's country, would the people of our country say, well, that's no problem, we can trade with them? Of course they wouldn't. And if their government said they would or should, the people wouldn't like it. And there's no difference between that and trading with, for example, North Korea, if a similar conclusion might be reached there. The people would like to know. And ultimately, the people just may be able to force the hand of political leaders and machinery that allows Article 1 of the Genocide Convention never to be honoured. So the People's Tribunal that was set up is completely independent. It was set up at the request of the World Uyghur Congress, and they provided some of the funding. Somebody's got to find money, and they will provide some of the evidence, but we are completely independent. And in setting it up, I was very concerned that we shouldn't have too many lawyers or experts in this, that, or the other thing. Why? Because this is a people's tribunal. It's a tribunal by citizens. Some of us are lawyers, but we won't act as lawyers. We will act as jurors. And we will start with a blank sheet of paper. We will assess what evidence is presented to us. Maybe we'll ask for more evidence. And we will be told what the law is by the very top lawyers in the relevant fields. And just like a jury, we will bring in we'll call it a judgment. It's not a report, it's not an opinion, it will be a judgment of certainty as to what has happened. And then we'll stop. We won't overreach and tell people what to do. It's not for us. It's reasonable to assume that once people are provided with a factual finding on an important issue about which they would want to know, that they will discharge their own personal and individual duties. And so that's how it works with us. Our tribunal is built on the experience and maybe the shortcomings and failings of earlier tribunals, in two of which I've also been involved in different and lesser capacities. But it's this business of saying, Jean-Paul Sartre said in the course of the Russell Tribunal, there's a gap. We are powerless. We fill the gap. Our powerlessness is our authority. At the end of it, here's a fact. Now, go use it. So that's what we do.
Thank you, Sir Nice. I am conscious of time and I want to open the discussion, open the floor for discussion. But before I turn to my colleague, Svetlina Van Bentum, to chair that part of the discussion, I will slightly abuse my privilege as the panel moderator to ask a question that I think some, at least of my students watching today, will probably be asking, which is the conversation started with the assumption that this is happening, right? How do we know that these allegations are even true? How do we know that it's not all propaganda? And the reason why I'm keen to cover this is because Christy and I, and of course, we've been working with Ambassador Rapp on that as well. We've been doing quite a lot of work in terms of the documentation capacity and power of the civil society. I just would love to give Christy an opportunity to discuss that, and maybe also briefly touch upon the impact that documentation technologies in particular can have with this type of remote assessments, given that we don't have access to these detention facilities in Xinjiang.
I mean, I can jump in. As I said earlier, there are leaked documents, there are cables and things from inside China that appear to be credible. Of course, it's also verified by satellite imagery, and we have limited testimony of people that have been in contact with their family members, and there've been some impact on Uyghurs living abroad on these crimes that are able to report it. Of course, Sir Geoffrey in his inquiry will have to deal with the strength of that evidence. I would point out that Foreign Minister Dominic Raab in his statement at the high-level week at the Human Rights Council this week called for a commission of inquiry or fact-finding mission of the kind the UN has established, or the Human Rights Council has established 24 times in the last 10 years, from Syria to South Sudan to North Korea to Myanmar, called for one of those. Now, that'll be close run. There's no veto there, but it would require more countries to vote yes than no, and that raises one of the issues I see in the questions about China's economic power and how countries will vote. So whether it'll happen or not, we don't know. But that could that kind of organization will also rely on interviewing of witnesses and digital information and look for credible documentation, et cetera. And that I think would be a very, very useful step. But we'll see whether the votes in Geneva in the 47-member Human Rights Council, where China and Russia are members and have many allies, but in other situations where they've opposed inquiries, it's been possible narrowly to win mandates.
Thank you, Mr. Rapp. Christy, did you want to add anything to that, or shall we turn over to Tina?
Well, if you'd like me to give an overview of some of the available technologies that I think are quite useful, then I'm very happy to do that. Otherwise, I'll wait for the questions.
I think if you can do that briefly, I think it would be interesting for the audience.
Great. Okay. Well, I mean, as Geoffrey's pointed out, and as Stephen's just highlighted, civil society advocacy is of course invaluable, not least for sort of raising awareness and governmental interest. And civil society and individuals on the ground, where they are able to communicate, are obviously, again, as Stephen's pointed out, an enormous resource. But even if international tribunals haven't quite caught up with this, we are in a new era of investigative opportunities. Even without access to crime sites, even without access to witnesses, we can still discern a lot. In the DPRK inquiry that Federico and I were both involved in, exploring the Kwan-Lee-so political prison system in North Korea, we relied, as is fairly obvious, on satellite imagery to prove the existence and indeed the apparent reconstruction of political prison camps that had been long contested by the North Korean state apparatus. Its use, to me, actually now seems quite commonplace in international proceedings. It's been used, as we've seen, in Sudan, South Sudan, CAR, DRC, Niger, Myanmar, and of course, in relation to Xinjiang. Other opportunities abound through the use of open source investigation, which is a growing area of digital open source investigation, which is a growing area. Bellingcat relied on videos posted online to challenge Russia about MH17. Then I think this is an interesting example of a sort of reciprocity between the public and traditionally private intelligence spheres. The Dutch joint investigation team and the Ukrainian security service then released telephone intercepts that independent investigators were able to verify against open source material, which led to identifying specific potential suspects for the MH17 downing. Even in Yemen, where one might expect very little evidence to be gatherable at the moment, there's a surprising volume of video footage emerging. the watchdog Air Wars, as Federica knows, I'm a big fan of their work, relies on open source material with the sort of dramatically challenge casualty estimates of militaries active there. Myanmar, we've got Facebook, other open source material, and interestingly, sort of big data analysis of the patterns of the Facebook traffic and the disinformation campaign by the Myanmar authorities. And that's what the Gambia relied on in its claims before the ICJ. Other stuff, call data records, which we use routinely in international law, cell site data, radio intercepts, footage and images, anything uploaded on the internet. We spend an awful lot of time scouring open source. You'd be astonished at what you can find. Comments and instructions and narratives posted online, financial intelligence. All of these intelligence tools are now in the hands of the public with enormous capabilities that used to be, confined to state authorities. So it's, I mean, to be honest, I think it's really exciting. Sure, there are new forms of deception. We can trick satellites, etc., but it's still, I think, got very exciting implications for accountability.
Thank you so much, Christy. That's extremely helpful. Now I will just turn it over to Svetlina and see what the audience has to ask.
Thank you, Federica, and thank you to all our panelists for their comments. And thank you, of course, to the audience for attending this event. It's wonderful to see so many of you on this call. We're now transitioning to the Q&A, and given time constraints, I will ask 3 questions at once. First, it would be good to start the discussion by posing a question on the UK Genocide Determination Bill, which was mentioned a number of times during the presentations. But it would be good to get a little bit more clarity, as this is of interest to many of us in the audience. So perhaps Sir Geoffrey and Kirsty could guide us through some of the more important aspects of that bill, as well as the impact that it could have. The second question is on what we can expect of institutions. And the question was posed in the chat on the Seed Business School, which is citing China as an example for business practices, and whether we should expect more or something different from our institutions. And the third one was posed by Telita de Sousa Diaz, our colleague from ELAC, and she's asking how to ensure the impartiality and hence the legitimacy of the Uyghur Tribunal if it is mainly funded by the victims or members of that community. And this question, I suppose, would be directed to Sir Geoffrey. Thank you.
Let me deal briefly with the parliamentary process, because it's far too complicated for the remaining few minutes. And indeed, the original plan has been much watered down by government attempts to block it or reduce it to being worthless. But the original plan was quite simple. If the suspicion of genocide, an interested party could go to a judge, it was argued, the judge says there's prima facie case of it, that would then involve the cessation of a bilateral trade deal. All of that's been diluted to an extraordinary extent, and it's a now complicated process proposed where if there is suspicion of genocide, then it goes to one committee and another committee made of judges, and then back to the first committee, and then to discussion in the House. It's extremely complicated. If it has any effect at all, it will be to deter the making of trade agreements with countries that are suspected of genocide, but it will not stop them. The second question that you asked me to deal with specifically is an interesting and important one about impartiality. There were two, but there's something on the chat line about that as well. I'm both interested and surprised at the question, how do you maintain independence if you're funded by, in part by a Uyghur organization? It's only partly by them, it's crowdfunding and all sorts of other sources. Tell me, who sought out the Nazis after the Second World War? Who were the Nazi hunters and by whom were they funded? They were the Jews for the most part, and quite right too. That doesn't mean at the end of that exercise, people identified as Nazi criminals were not Nazi criminals, because they most certainly were. Who else is going to fund an independent people's tribunal in the first place but the people who have an interest? But that doesn't mean to say that taints us at all, and indeed it most certainly doesn't. We have a tribunal specifically sought not to have people from one side or the other. We're none of us activists, none of us interested particularly in China as a source of suffering. There's plenty of sources of suffering all around the world. Our sole concern as academics, businessmen, one or two people with backgrounds in the law but not using the law, somebody in education, somebody in diplomacy originally, two medics, a wide range of people, no particular interest, who will just assess the evidence. It's exactly the same that happens when the CPS, an interested party, you might say, brings a criminal case before a court. So there's no problem with that. Do we, and I'll finish now with this, have we got somebody, it's said, from the other side on the tribunal? Well, we are not one side. We have no starting point. We take no notice of what Pompeo says, no notice of the decision of the Canadian government, no notice of the Dutch government. We start with a blank sheet of paper, but we will go out and do everything we can to find what the position of China is. And of course, we've written to them in advance already many times, asking them to contribute, to come to the tribunal and so on.
Christy, perhaps over to you.
Hi there. I'm afraid I actually dropped out for a moment, so I missed the beginning of that. I had a question for Jeffrey though, which was you've chosen to call it a tribunal, and I was wondering if you'd explain that choice, because that's for sort of settling a dispute. You've just said it doesn't have a side. We chose to call the this is very apocalyptic. The lights have gone off. We chose to call the North Korea proceedings that we conducted an inquiry. So I'd be curious to see why you've chosen tribunal.
People's tribunals have been called people's tribunals since the 1960s. We're following the same course that they did to fill a gap. And I think the word tribunal is more appropriate, Kirsty, because what happens with a report is that you find that governments can say, well, this report says this thing or that thing, or it adopts that opinion or that, or another opinion, and we can disregard it. At the end of this exercise, the 9 members of the tribunal, if they reach any conclusion, will reach it so that they are sure, beyond reasonable doubt. They will deliver a judgment, and they will hand that fact to other people. And that's why we will apply the strictest conception of evidence that we possibly can to reach that conclusion. Tribunal is probably the more appropriate term, and it's more likely to have an effect. Reports sadly don't. I heard, speaking of the Commission of Inquiry reports, that it's argued might be organized by the Human Rights Council. Unlikely. And maybe Dominic Raab thought it was unlikely when he proposed it. But remember, the phenomenally good COI report of Justice Kirby into North Korea 4 or so years ago, blocked, of course, as it would have been at the Security Council, having a successful General Assembly hearing, has sat on a shelf to such an extent that Kirby, Sonia Biserko and Darusman have now written to the Human Rights Council bemoaning the fact that actually that inquiry report has had no consequences, begging lawyers now to be imaginative and do something further. So I think tribunal is the right word.
Well, when you said about evidence being held to the very highest, and I'm sure I know with your background and your lengthy, distinguished experience, you know exactly what that means. But how is it being tested?
Well, it's being tested by, first of all, by the panel members, and you test it in the way that you test any other evidence, by asking questions, by looking for things that are compatible with other evidence, things that are not compatible. You recognize, of course, we're not going to go through the adversarial system, because it isn't possible. There isn't an adversary. China is unlikely to turn up, and even if it did, it would be unlikely to take part in a way that would be constructive on an adversarial basis. So it's an inquiry, and you take into account the fact that the evidence is not being tested by an adversary. That doesn't make it impossible to form a view upon it. It's the sort of conclusion that people, it's the sort of decision-making process that people, particularly the wide range of people on the tribunal, are used to dealing with on a regular basis. It's lawyers who get hung up on this, that, and the other thing. Scientists and other such people, if they can't find an answer to a question by one route, they go and find another route to it, and they get there in the end. You need to be thoughtful, imaginative, and you don't need to be tied down to old-fashioned approaches to these things that favor lawyers and judges. And just think how useless lawyers and judges have been. Genocide, at least it's been tried now for 20 years with no satisfactory conclusion. The law that must be told to us in terms that can be understandable by citizens is incomprehensible to a perpetrator or to a victim at the moment. Just think about that. That's the law we lawyers are trying to apply. This tribunal will have the law presented to it in as simple and straightforward a way as it can be. It will apply that to the facts it will find. It will always operate on the basis of either whatever it is, the highest common factor or the lowest common denominator. We won't make a finding of certainty beyond that of which everyone is agreed. That is what we will present at the end of it by a tribunal.
And I think we're very near the end. I had an economic question, and I do think it's important that states use their sanctions laws and groups of states to go after companies that use Uyghur forced labor, for instance, in the supply chain. And I know we've got 20% of the cotton, for instance, coming out of Xinjiang in world supply chain. So I think you can have an impact. Obviously, China, very powerful country, can shift things around, but it needs to be a consistent kind of policy and also to go after these key individuals, the Sheng Guangguos, et cetera, that are really the heavies, and clearly call them out and sanction those individuals and seek out their resources and their assets in foreign banks. And it can have an impact. Obviously, we're hoping that at the end of the day, China would moderate its strategy here. I mean, China does want to be popular worldwide. It's done a number of things quite negatively that I think have undermined its strength, and we see that in the fact that the Islamic countries lined up against it on the Rohingya issue and supporting the Gambia case. So I do think that it's not without the possibility of having some influence through these economic tools, and all countries and groups of countries should consider those steps.
Thank you, all three of you. We only have 1 minute, so I think we can wrap up with one question about what we as individuals can do, which was sent to us via chat. So perhaps with one sentence, if you could tell us what each of us can do to put some pressure on governments for this particular instance, but also generally when there are serious allegations of human rights violations. Thank you.
Well, I mean, to ask for effective action by your government to make your foreign policy not just a matter of self-interest, but on shared human values, and find ways to leverage that domestically and then in partnership with other states to have an impact.
So far as I'm concerned, the last sentence of the judgment of the China Tribunal reflects what any citizen should do. Once you know a fact, you don't have to know it's for a tribunal. Once you know a fact as a citizen, whether you're an educational establishment, a business, a travel company, whatever it is, apply that fact to the decisions you make about any interactions you may have with a country that you believe or know to be doing bad things.
I think as individuals, we all have power to influence the companies that are operating and benefiting from these institutions. I mean, if you've got 20% of the world's cotton coming from Xinjiang, then if you start demanding that your clothes from Arket, etc., come from verifiably safe, torture-free environments, then that's going to put extreme pressure on these companies, which have the power to exert influence in China, presumably. There are companies that are not responding to these calls, and I personally have stopped. I won't shop there, and I think that if lots of people do that, then we'll see a real shift in the commercial realm.
Thank you all. That is helpful for all of us on this call. Perhaps back to Federica for some closing remarks.
Yes, thank you to Svetlana. I see that there's so many more questions in the chat box. We tried to answer some directly, but unfortunately we can't get through all of them because we have another event lined up, and so we do have to stop the conversation promptly. But I just wanted to thank all the panelists for this profoundly insightful discussion, and for your participation, for sharing your view, your expertise with us and with our audience, and also for engaging with one another. Of course, I want to thank all the organizers, as well as our colleagues at the Blavatnik School, and of course the audience who's participated, who's attended, and who's asked many interesting questions. And we'll have to interrupt the conversation for now, but we look forward to reconvening at some other time. And of course, if you're interested in learning more about our work, you can read our submission, which I've shared in the chat box. You can also visit our website if you're interested in our work on atrocity prevention and broader issues. Thank you, everyone.
Thank you.
Thanks very much.